This is Mr. Lim, the owner of a successful electronics retail store in Malaysia, who decided it was time to sell his business and retire. Soon, he entered into negotiations with Mrs. Tan, an aspiring entrepreneur eager to take over his well-established business. As part of the sale agreement, Mr. Lim insisted on including a clause that prohibited Mrs. Tan from engaging in a similar business within the same city for a period of 5 years after the sale. Mrs. Tan, eager to acquire the established customer base of Mr. Lim, agreed to the clause without fully understanding its legal implications. However, Mrs. Tan later became concerned about the legality of such a restraint of trade clause. She began to worry about its enforceability and what it might mean for her future business opportunities. Seeking clarity, she sought professional advice. Subsequently, Mrs. Tan hired Mr. Ahmad as the sales manager for her newly acquired electronics retail store. As part of his employment contract, Mr. Ahmad agreed not to work for any competing electronic stores within a 10-kilometer radius of the business premises for the duration of his employment and for a period of 2 years after its termination. Mr. Ahmed, excited about the opportunity to advance his career, signed the contract without considering the implications of the non-compete clause. Later, Mr. Ahmed began to question the enforceability of the restriction and its potential impact on his future job prospects. Both Mrs. Tan and Mr. Ahmed found themselves in a situation where the legal enforceability of their agreements came into question, highlighting the importance of fully understanding the implications of non-compete clause in business and employment contracts. Concerned, both Mrs. Tan and Mr. Ahmed decided to seek legal advice and, coincidentally, arrived at the same law firm simultaneously. As they entered the firm's consultation area, they were greeted by the two chambering students and were ushered to sit down in the office of a seasoned lawyer who was there observing the consultation. The lawyer, understanding the complexity of their issues, suggested they schedule a formal consultation for a thorough review.
Hi, welcome to S Company, Miss and Mr.
Joining us today, here are two of our temporary students.
Alright, so before we start, we would love to know a bit about Miss and also Mr. Can you introduce yourself?
I'm Mr.
And my name is Mr. Ahmad.
And you can just call me Miss Adila.
And you can call me also as Mr. Aki. Well, Mr. and Mrs. Maybe know the problem faced by both of you. What is the matter that brings you two here today? You can find and suggest the best solution.
Before we start, it's just a consultation between us and we only provide legal advice for you. Both of you are not bound by the advice given and it is up to you to make a decision at the end of our session today. Any information shared today is private and confidential. Is it okay? Miss and
Last month, I signed an agreement to purchase business from my fellow entrepreneur. And because I was too eager, I had agreed to a clause that was without fully understanding the implications and its limitations.
can you repeat the clause in the sales agreement then as you don't have a full knowledge about the clause?
The clause is about prohibiting me from engaging in a similar business within the same city for a period of 5 years after the sale.
Miss Ahmed, how about you? Can you tell us about your story?
So recently I got hired in an electronic sales company. I signed an agreement where I stated that I cannot be working in any competing business premises for along the employment period and also 2 years after my termination within 10-kilometer radius. At the start, I got very excited and I just signed the agreement without even thinking about the consequences. And after a while, I realized that this agreement might affect my future prospects. So that is why I'm going to proceed to legal advice.
Well, before we get deeper, do you know about restraint of trade? Basically, restraint of trade is normally employment in employment contract because it is so as not conflict clause. So if you can see in this Contract Act, Section 28, agreement in a restraint of trade void, every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is pleaded as and void. There are three exceptions, which are first, saving of agreement not to carry on business of which goodwill is sold. One who sells the goodwill of a business may agree with the buyer to refrain carrying on a similar business within specified local limits, so long as the buyer or any person driving title to the goodwill scheme carries on a light business bearing, provided that such limit appear to the part reasonable regard being had to the nature of the business. So the second one is of agreement between partners prior of the dissolution. Partners may, upon or anticipation of a dissolution of the partnership, agree that some or all of them will not carry on a business similar to that of the partnership within such limits as referred to in Exception 1. So the last one is during continuance of partnership, the partners may agree that someone or all of them will not carry on any business other than that of the partnership during the continuance of the partnership. Is it clear?
If you, Mr. Ahmad, does not believe in us, you can refer to the case of Long Horizon Health Service LLB, which reflects Long was employed by Horizon Health Services and was subject to a non-compete clause that restricted him from working in a similar capacity for 2 years after leaving the company, and Long challenged the enforceability of the clause, arguing that the 2-year duration was excessive and unreasonable, and the court held that the 2 years non-compete clause was unreasonable as it excessively restricted Long's ability to work in his field and earn a living. As we can apply in your situation, which the duration is similar to the Long's case, which Mr. Ahmad, non-compete clause also stipulates a 2 years restriction period from working. This case suggests that the 2-year duration might be seen and excessive, especially if it significantly impacts Mr. Ahmad's ability to find employment in his field.
For instance, there has a case, it is LLB International Studio High and June 24, 1995. LLB International sold its business and included a non-compete clause in the sale agreement, restricting the seller from engaging in a similar business within a specific geographic area for a specified period. June 24 challenged the possibility of non-compete clause. The court held that the non-compete clause was valid and enforceable because it fell within the scope of Exception 1 of Section 38 of the Contract Act. The contract found the geographic limit and the duration of the restriction reasonable given the nature of the business and the need to protect the buyer's interest. To apply this case, assuming that Ms. Lim sold the goodwill of the business to you and included a non-compete clause in the sales agreement. And the purpose of the non-compete clause is to protect the buyer, which is you, interest in the business by preventing the seller, which is for immediately starting a political business that could undermine the value of your goodwill sold. Is it clear?
Yes. I understand that when the legal implications of the contract.
Sure, that's what Ms. Adila said just now. What is we know the basic of restructure, right? A few legal implications that we must take note of it. And there are few remedies available under both situations. Similar to Section 28 of Contract Act, Section 1, like Mrs. Adila said, it's a goodwill of someone. So this provision essentially allows for non-compete clauses when the goodwill of a business is sold, as long as the terms are reasonable. Clear? Since the contract is valid, so Mr. Tan, you are bound to the contract, and it is your obligation to follow the contract as what it is. In your situation, Mr. Tan, the non-compete clause protects his investment by preventing Mr. Lim from competing and undermining the business value. If Mr. Tan breached the contract or the clause, Mr. Lim can enforce it through legal action to protect his business value. This ensures the stability and value of the acquired business. The remedies available under your situation is there is no specific remedies, since the contract is valid and Mr. Tan is bound by the contract, and it is your obligation to follow the contract as what it is.
What about in my situation? What are the remedies and the legal implications in the case?
For your case, we can start by the legal implication. You can challenge the legality of 2 years non-compete clause, and you can have significant legal implication for both parties. Either you are successful or unsuccessful. Employees face the risk of legal costs, potential damage, and reputational harm if the clause is deemed unreasonable, and employees risk serious regret, financial loss, and legal expenses if the non-compete clause considering the employee's legitimate business interest, the duration, scope of the age registration, public interest and employees' right to both parties should carefully consider this implication. And for your remedies, Mr. Ahmad, there are 4 remedies available under your situation. You can start by specific performance, which is you and Mr. Tan, you must have mutual agreement, which is you must redone contract, or you can have a negotiation to have a new contract. Thus, the court can make a specific performance to perform the contract, which is the modified terms. And the next one is injunction. Injunction, the purpose of injunction in court is not to change clause in the contract, but it is to lift up the impossibility of the validity of the contract. It is just for temporary, since the injunction has two purposes, the permanent one and the temporary. And the third one is blue cancelling, or also called as reformation. This is the court have the authority to change the terms in the contract, which is if the court thought that there are a clause that is unreasonable, then the court have the power to change the terms into the reasonable and into your favor. The last one is damages. As you know, you have a career setback, which is you have lost your job for within 2 years of years, right? Therefore, you can ask for damages from the court if you already go through 2 years without working because of the implication of this contract.
Can you please advise me on the legal strategies and what I should do?
Sure, but unfortunately, I would like to say sorry first because this time there's nothing we can do because of the validity of the contract itself. Since your situation right now, it supports the validity and impossibility of such non-compete clauses. Because the non-compete, they are designed to protect the goodwill sought and are reasonable in scope and duration. Thus, the non-compete clause in the contract between Mr. Lim and Mr. Tan is likely to be upheld as valid and reasonable under Malaysia. And the ratio will be 80% if you still wanted to file a legal suit and you want to challenge the validity and file a law case about this. But we discouraging you, Mr. Tan, to file a law case. But once again, I would like to emphasize that this is an only advice for you, and you are not bound by it.
How about my situation? What is the least thing that I can do?
For your submission, there are 2 legal strategies. First is litigation, and second is ADR, which is alternative dispute resolution. For your information, litigation is an act, process, or practice of settling a dispute in a court of law. It is a litigation or proceeding such as a lawsuit. But we only use this if the ADR method is unsuccessful.
Moving on to Mr. Ahmad, yes, where we will be focusing on the non-compete clause in the employment contract. Firstly, our firm will recommend that Mr. Ahmad to address the non-compete clause by seeking legal advice, like how he came to our firm today, as our firm specializes in contract law. Therefore, we are eligible to evaluate the impossibility of the clause of non-compete clause between him and Mr. Tan. We will assess on the reasonableness of the clause in the terms of operations, the scope of the area, and also the necessity to protect Mr. Tan's business. Secondly, we would like to recommend to Mr. Ahmad to come to us another time with Mr. Tan for an alternate dispute resolution, which is ADR. The method that we will use will be mediation. In the meeting between these two parties, with a separate time and place the method, we will propose for them to have a renegotiation on the terms of the clause, which will lead to a mutual agreement. The renegotiation of the methods of the clause and the impact of the clause towards Mr. Ahmad's future opportunities in the field. We will also suggest to Mr. Tan to make modifications which are more reasonable than the one currently, thus protecting both Mr. Tan's business and Mr. Ahmad's future endeavors. Third, suppose the negotiation made in ADR is unsuccessful, in that case, Mr. Ahmad can consider to challenge Mr. Tan in court regarding how the non-compete clause is overly restrictive and it's unnecessary to protect a person's business. The evidence provided would be on how this clause would impact a person's career. Last but not least, we would recommend to both Mr. Tan and Mr. Ahmad to next time properly check and understand the terms of the contract that they signed, and if possible, have a lawyer to review it. In that case, me and Ms. Anila would like to take some time to review it. This is the result of our discussion just now.
I think this is more in my favor, so there is a contract between us, right? And I also can argue the contract. Is that right?
Yes, Miss, you are right. Is there anything else Miss Tan and Mr. Ahmad would like to ask us?
I guess so.
I'm glad that I went to consider you guys. You guys are very interesting. And first, instead of making another offer to someone else. Thank you.
You can follow us. Son, Mr. Ahmad.